Federal Judge Arthur Angeron just issued an order that has sent shockwaves through Manhattan and Washington. Trump's most prized properties, including Trump Tower on Fifth Avenue, now face immediate seizure to satisfy a $464 million judgment. And this isn't some procedural formality or temporary freeze. This is the actual confiscation of real estate assets that Trump has spent decades building his identity around. When a New York judge authorizes state officials to begin liquidation proceedings on properties worth hundreds of millions, you know we've crossed into territory we've never seen before with a former president. Hit that subscribe button right now, because you won't want to miss any of the videos I release. So, what triggered this unprecedented enforcement action? Judge Angaran ruled on January 18th that Trump's continued failure to post the required appeal bond constituted willful defiance of the court's February 2024 fraud judgment. According to court documents filed by New York Attorney General Letitia James, Trump has had over 11 months to secure the bond or arrange payment, yet has refused every reasonable accommodation offered by the court. This isn't just another legal setback or political controversy. Members of Trump's own legal team have privately acknowledged to associates that the situation has reached a critical breaking point. And believe me, when a federal judge moves from warnings to actual property seizure orders, something massive has just detonated. Here's the full picture of what's been unfolding. Tensions between Trump and New York state authorities have been building since September 2022, fueled by the Attorney General's sprawling civil fraud investigation, Trump's combative courtroom behavior, and repeated missed deadlines for compliance. But everything escalated on January 18, 2026, when Judge Angeron signed an enforcement order specifically identifying 7 properties now subject to immediate seizure proceedings. The order dated exactly 336 days after the original fraud judgment lists Trump Tower's commercial units, his Westchester golf course, and his Wall Street office building as priority targets for liquidation. This wasn't about minor accounting disputes or technical violations. The judge's order explicitly states that Trump inflated asset values by more than $2.22 billion to secure favorable loan terms, defrauding lenders and insurers through what the court called a systematic pattern of financial misrepresentation spanning decades. The ruling describes conduct so egregious that even Trump's own accountants severed their relationship and withdrew previously certified financial statements. Smash that like button if this is making sense so far. Here's where it really gets serious. When the New York Attorney General's office received authorization to proceed with seizure, they immediately filed notices of intent with property managers at Trump Tower and contacted commercial tenants about the upcoming change in ownership. Sources familiar with the enforcement proceedings told Reuters that state officials are moving with unusual speed, likely anticipating resistance. And let's be honest for a moment. Court-ordered seizures of a former president's properties are extraordinarily rare. They don't happen over ordinary business disputes or political disagreements. They happen when a judge determines that a defendant has systematically defied court orders and exhausted every opportunity for voluntary compliance. Here's what multiple sources close to the proceedings say happened next. On January 17th, a group of Trump's attorneys held an emergency meeting at his Mar-a-Lago estate after Judge Angeron's chambers notified them that an enforcement order was imminent. The legal team included Christopher Kiss, his lead attorney in the fraud case, along with advisors from 3 different law firms. Sources told the New York Times that Kay warned Trump in explicit terms that the judge had run out of patience and that seizure proceedings would begin within 48 hours unless he immediately posted at least a partial bond. Trump reportedly dismissed the warnings, insisting that the appellate courts would intervene or that Republican governors would somehow block New York state enforcement. By the evening of January 18th, Judge Angeron had signed the order, authorizing New York Attorney General Letitia James to begin seizing and liquidating properties to satisfy the $464 million judgment, plus accrued interest, which had grown to $478 million. The order states that Trump's continued refusal to comply with court directives demonstrates a pattern of deliberate contempt that requires immediate enforcement remedies. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild. On the morning of January 19th, attorneys from the New York Attorney General's office appeared unannounced at Trump Tower on Fifth Avenue, carrying court orders and accompanied by two deputy marshals from the New York County Sheriff's Office, according to building security personnel, who spoke with CNN. The attorneys presented paperwork to the property management company and informed them that the state was now assuming control of the commercial portions of the building pending asset liquidation. Witnesses in the lobby described a surreal scene as state officials set up a temporary command center in a conference room, while Trump Organization employees were notified that they no longer had authority to make decisions about the property. One longtime building manager told reporters that in 27 years of working at Trump Tower, he never imagined he'd see the day when the state arrived with court orders to take over the building. The symbolism was impossible to ignore. Trump Tower, the 58-story monument to Trump's brand that he built in 1983 and has served as the physical embodiment of his business empire, was being stripped away by court order in broad daylight. That's when it became clear this isn't just another legal dispute or political theater. The bombshell moment came when Attorney General Letitia James held a press conference at 2 p.m. outside the New York State Supreme Court building. Reporters in the chamber described her tone as measured but unambiguous, as she announced that her office had formally taken possession of Trump Tower's commercial floors and would begin the process of selling them to satisfy the outstanding judgment. This move sent shockwaves through the New York real estate community and Republican leadership circles. When a state attorney general publicly seizes properties from a former president and announces plans for immediate liquidation, it signals one thing: the legal system is proceeding exactly as it would for any other defendant who defied a court order. The claims of political persecution collapse when judges follow standard enforcement procedures that apply to every New York resident facing civil judgment collection. This isn't the first time a court has threatened to seize Trump's assets over financial disputes. Think back to 1990 when Trump's Atlantic City casinos faced bankruptcy and creditors circled to claim his personal holdings. Trump narrowly avoided losing his yacht and his stake in the Plaza Hotel by negotiating emergency restructuring deals with banks at the last minute. Then there was the 2006 Trump University litigation, when former students sought court orders to freeze Trump's assets pending resolution of fraud claims. Trump settled that case for $25 million in 2016, avoiding asset seizure entirely. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the massive civil judgment against Trump in the E.N. Carroll defamation case, where an $83.3 million verdict was entered in January 2024. Trump posted an appeal bond in that case within weeks, avoiding any seizure action. Now, however, it's different. This time, Trump has refused to post bond, despite having more than 11 months to do so. The pattern is clear. When Trump faces judgments, he believes he can appeal away or delay. Indefinitely, he refuses to comply with standard procedures for securing appeals, gambling that courts won't actually enforce their orders against a former president. So what triggered this unprecedented enforcement? According to legal experts who reviewed Judge Engoron's seizure order, Trump's actions violated fundamental principles of civil procedure and judicial authority. The order notes that despite being given multiple extensions and accommodations, Trump failed to post the required appeal bond failed to arrange a payment plan, and failed to demonstrate any genuine effort to satisfy the judgment. New York law permits judgment creditors to seize and sell a debtor's property when voluntary payment is not forthcoming. Judge Angeron's order specifically cites Trump's public statements, dismissing the judgment as invalid and vowing never to pay as evidence of bad faith that justifies immediate enforcement. Here's the kicker. The order includes references to Trump's social media posts, bragging about his wealth, while simultaneously claiming he cannot afford to post the required bond. The judge wrote that Trump's position is internally contradictory and demonstrates willful defiance rather than genuine financial inability. This wasn't a dispute about whether Trump had the means to comply. Court-appointed monitors estimated Trump's liquid assets at well over $400 million based on his own financial disclosures. It was an explicit refusal based on Trump's belief that normal legal processes shouldn't apply to him. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone. This isn't just about one judgment or one set of properties. If a former president can openly defy court orders for nearly a year, refuse to follow standard appeal procedures, and face no enforcement consequences, the entire civil legal system loses credibility. Once that precedent is set, there's no turning back. Every future defendant would claim similar immunity, arguing that if Trump could ignore judgments, why can't they? This puts Trump's political and legal teams in a nearly impossible position. On one side, they face pressure from Trump's base to fight every step of the way to claim this is political persecution, and to position him as a victim of a corrupt legal system weaponized against him. That means continuing to defy the court, attacking Judge Angeron publicly, and framing the seizure as an illegal assault on Trump's rights. On the other side, they must reckon with the reality that major financial institutions are watching closely. When properties are seized and liquidated because Trump refused to post standard appeal bonds, lenders and business partners see a person who doesn't follow basic legal and financial norms. And here's the tricky part. There's no credible defense. Either Trump lacks the financial resources to post a $464 million bond, in which case his claims of being a billionaire are vastly overstated, or he has the resources but is willfully refusing to comply, in which case he's in contempt, and seizure is the appropriate remedy. Courts have already rejected Trump's arguments that the bond requirement is excessive, with appellate judges ruling unanimously that the amount is standard for judgments of this size. Legal and political analysts are calling this a defining moment for accountability. Barbara McQuaid, former U.S. attorney and University of Michigan law professor, told MSNBC that if the seizure order is carried out, it represents a clear demonstration that no one, regardless of political status, is above the law. She explained that civil judgments are enforced through property seizure all the time in New York courts. But this is the first instance involving a former president, which gives it extraordinary symbolic weight. Andrew Weissman, former FBI general counsel and prosecutor on the Mueller investigation, added that Trump's refusal to post bond reveals a fundamental miscalculation by gambling that courts wouldn't actually seize his properties. Trump may have backed himself into a corner where he loses assets worth far more than the judgment itself, since liquidation sales typically occur at significant discounts. Do me a favor and slam that like button, because it genuinely helps this video reach more people. Even Jonathan Turley, a George Washington University law professor who has frequently defended Trump in legal matters, acknowledged that the situation is extraordinarily serious. He told Fox News that while he believes the original fraud judgment was excessive, Trump's refusal to follow standard appeal procedures has eliminated any legal basis for blocking enforcement. Turley emphasized that judges cannot allow defendants to simply ignore judgments they disagree with, regardless of who that defendant is. So, let's break down what this could mean. First, the immediate financial impact is staggering. Trump Tower's commercial floors are estimated to be worth at least $290 million based on recent comparable sales in Manhattan. However, forced liquidation sales typically fetch only 60 to 70% of market value, meaning Trump could lose an asset worth nearly $300 million to satisfy a judgment that might have been resolved by posting a bond and winning on appeal. If the seizure extends to his Westchester golf course and Wall Street office building, total losses could exceed $400 million in real property value. Second, it creates catastrophic damage to Trump's business empire and personal brand. Trump has spent 5 decades building his identity around Manhattan real estate and his status as a successful developer. Losing Trump Tower, the crown jewel of his portfolio, to a court-ordered seizure permanently undermines that narrative. Every business partner, lender, and potential investor sees someone who defied a court order and lost his most valuable assets as a result. That reputation damage will persist, regardless of whether Trump eventually wins any appeal of the underlying fraud judgment. Finally, the broader political implications are profound. Trump's campaign has consistently portrayed him as a savvy businessman and fighter who outsmarts his enemies. Losing properties through court-ordered seizure because he refused to follow standard legal procedures tells a very different story. It shows someone who miscalculated badly, who gambled that his status would protect him from normal consequences, and who lost spectacularly. Campaign ads are already being cut by opposition groups featuring images of state officials taking control of Trump Tower while asking voters whether this is the judgment they want in the Oval Office. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate financial and political fallout, this is really about fundamental constitutional principles. The civil legal system depends on the principle that court orders must be obeyed. When judges issue judgments, defendants must either pay, post bond to appeal, or face collection actions. If former presidents can simply ignore those requirements, the system collapses. Courts have limited tools to enforce their orders. They can hold defendants in contempt. They can fine them, and they can seize property when all other enforcement mechanisms have been exhausted. Seizure is the final option. Judge Angeron's order makes clear that Trump received every possible accommodation and ignored all of them. At that point, the judge had no choice but to authorize enforcement or risk signaling that court orders are optional for politically connected defendants. This scenario is causing sheer panic within Trump's remaining legal team. Reports indicate that attorneys held emergency conference calls on January 19th to determine how to respond. Some argued for immediately seeking an emergency stay from federal courts, claiming New York state courts are biased. Others insisted that defying federal intervention would only make matters worse, and recommended negotiating a settlement with the Attorney General to stop the liquidation process. Meanwhile, Trump's core supporters are absolutely furious at what they perceive as a corrupt legal system targeting their candidate. Social media is flooded with calls to protest at Trump Tower and boycott New York businesses. They're claiming this is election interference designed to bankrupt Trump before the 2026 midterms. To the base, this is proof that Democrats will use any tool available, including the courts, to destroy Trump. Things escalated further when Trump himself responded with a series of posts. On Truth Social, he called the seizure order illegal and unconstitutional, claiming that Judge Engram is a partisan hack who has been trying to destroy him for years. He specifically attacked Attorney General Letitia James as a racist who ran for office promising to target him, and he vowed that his properties would never be sold because appellate courts would intervene within days. Trump's posts included threats to countersue everyone involved and predictions that the seizure would backfire politically by energizing his base. Stay with me. What comes next will completely change how you view the situation. Here's what makes it even more extraordinary. Trump's response completely avoided addressing the fundamental question: why didn't he post the required appeal bond? New York's appellate division already ruled that the bond amount is appropriate given the judgment size. Trump claimed publicly that no bonding company would accept real estate as collateral, but experts pointed out that he could have sold assets, taken out loans, or arranged payment plans with the court. His refusal to pursue any of those options is what triggered the seizure. Legal experts immediately flag the strategic disaster. When your defense is attacking the judge and the attorney general, rather than explaining why you didn't follow standard procedures that every other defendant must follow, you've already lost the argument. Renato Mariotti, a former federal prosecutor and legal analyst, tweeted that Trump's response confirms he has no legitimate legal defense for his non-compliance. So he's falling back on political attacks and hoping his base creates enough pressure to force some kind of intervention. This goes far beyond one judgment or one set of properties. It's about whether former presidents are bound by the same legal rules as everyone else. If Trump can defy court orders for nearly a year without consequence, every future president will know they can do the same. If courts issue judgments and former officials simply refuse to comply, counting on their political status to protect them, the civil legal system becomes meaningless for the powerful. If there are no consequences for Trump's defiance, it signals that political status creates immunity from ordinary legal processes. It's not just about this case or this judgment. It's about whether the office of the presidency, even after someone has left office, creates a permanent shield against accountability. If this blows your mind, hit that like button right now. Here's the situation. A federal judge has authorized New York state officials to seize and liquidate Trump's most valuable properties to satisfy a $464 million civil fraud judgment after Trump refused for 11 months to post the required appeal bond. State attorneys have already taken possession of Trump Tower's commercial floors. This is no longer a theoretical possibility or a distant threat. It's happening right now. When state officials show up with court orders and begin the process of liquidating properties that a former president has claimed define his identity and success, we've entered genuinely unprecedented territory. If there are no consequences for Trump's year-long defiance of court orders, it sets a dangerous precedent. Future defendants would point to this case as proof that powerful individuals don't have to follow the same rules as everyone else. Keep a close eye on this story. Legal analysts expect Trump's attorneys to file emergency appeals with federal courts within the next 48 to 72 hours, arguing that New York courts are biased and that federal intervention is necessary. The New York Attorney General's office has indicated they will proceed with liquidation proceedings regardless of emergency appeals unless a federal appellate court issues a stay. And property appraisers and potential buyers are already circling, knowing that forced liquidation sales often create opportunities to acquire valuable Manhattan real estate at steep discounts. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. New York state authorities have seized control of Trump Tower's commercial floors pursuant to a judge's enforcement order. Trump has vowed to fight, but hasn't posted the required bond after nearly a year of opportunities to do so. Legal experts say seizure and liquidation proceedings will likely accelerate over the next 2 to 3 weeks, unless Trump suddenly changes course and arranges payment. This isn't just another news cycle that will fade away. This is a fundamental test of whether the civil legal system applies equally to former presidents. What happens next could determine whether court orders carry weight for all defendants or whether political status creates a permanent immunity that undermines the entire concept of equal justice under law. The evidence is documented in court filings spanning nearly a year. The seizure order has been issued and is now being executed. Now, we wait to see if Trump will finally comply with standard legal procedures, or if courts will follow through with liquidation sales that strip away properties he spent decades claiming define his success. The stakes have never been higher. The enforcement action has never been more real, and the constitutional moment has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.